This is an appeal in the matter of UK Insurance Limited and Attersley.
Yes, Mr. Roy.
If it pleases the court, I appear for the defendant, appellant in this matter, my lord and friend Mr. Hutton, King's Counsel, leading Mr.
Yes.
Mason for the claimant respondent. The court will have seen this is an important point on the interaction between fixed costs and Part 36.
Yes. Yes, I can tell you that we've read the skeleton arguments, we've read the judge's judgment, and we've read the circuit judge's judgment.
My lord, I'm obliged. So you'll see it comes down to this. The claimant accepted an offer late.
Yes.
In time, fixed costs, what's the effect of late? The claimant says we get higher costs for accepting late.
Yes.
And we say, no, you shouldn't. That's really the key point.
And on the facts, the offer was made and the period for acceptance expired before the case was allocated to the multi-track.
Precisely so, yes. Might assist the court just to look at the effects of those propositions as regards figures. So could I invite the court please to look at towards the end of the supplementary bundle, page 135, 135 therein.
Sorry, which page?
135.
Yes.
And bottom of that page, grand total, and this is the fixed costs, grand total inclusive of VAT and everything else. It's around 56,500.
Yes.
Then if we could look please at page 139, 139. Bottom of that page, we see the grand inclusive total for the conventional costs.
Yes.
That's a bit under 111,000. The disbursements are the same in both sets of costs. So perhaps the more illuminating comparison is with the profit costs. So if we could please jump back to page 134. And towards the top of that page, we see the fixed profit costs, 10,610 plus VAT. So a little over 12,500 fixed profit costs.
Mm-hmm.
Then page 138, 138. Towards the middle of that page, just above counsel's fees, we see the figures for conventionally assessed profit costs, 56744 plus VAT. So a little over 68,000, nearly 5.5 times the fixed cost figure. It's a significant difference. The disbursements might be assessed down in both cases, and the profit cost would be in the conventional cost case, but even says reduces the profit cost figure by a third on assessment. One would still have a figure of about 45,000 or thereabouts, so over 3 times. So whichever way one looks at it, on the claimant's interpretation, the claimant gets much higher cost for accepting late than accepting in time. And my headline point is that simply cannot be right. That would be an absurd result in the broad sense of the word. Be contrary to common sense. Litigation common sense, if I can put it like that. Contrary to how civil costs are supposed to work in general. Contrary to how Part 36 in particular is supposed to work. And notwithstanding the detailed analyses you'll hear from both myself and Mr. Hutton, that really boils down to that point. If the court accepts the proposition, that cannot be right. One way or another, the appeal should be allowed. If the court does not,
Well, whether it can or can't be right depends on the rules.
it does. Well, of course, although that's there are 2 grounds. I say if I'm wrong in the rules, my ground 2 will get me home if I'm right in that basic proposition. Just briefly to explain why it's such wide importance, there's obviously not an unusual scenario in late acceptance in these circumstances. It's also uncontroversial to say fixed costs are an important part of civil justice, and all the more so because, of course, they've been massively expanded recently. Formerly, it was limited classes of claims worth up to 25,000, and now it's nearly all civil claims worth up to 100,000. But the rules on this point are, for material purposes, the same. So there are cases stay pending outcome of this appeal. I raise that point because the right answer has got to be the right answer across all these cases, irrespective of the right answer here. For, in our different ways, myself and Mr. Hutton both say that the justice of the individual case accords with the broader spectrum justice, but the point remains, this is a test case and a point of principle, and that is relevant to the approach to interpretation, or, under my second ground, to the points of principle I'm inviting this court to lay down if needs be. You'll see, the court will say now I have two grounds. My first ground is simply on proper interpretation of the rules, fixed costs apply directly and automatically, subject always to the exceptional circumstances get out. If I'm wrong about that, I invite the court to hold that they should apply indirectly by reference to the principle in the case of Williams. I'm obviously aware my Lord Justice Lewison gave judgment there, so I'll make points about that as deferentially as I can. The second ground is shorter, but it's not a make-weight one. If I'm wrong on ground one, that is a complete and freestanding basis upon which the appeal should, in my submission, succeed. There is a respondent's notice. As I read it, with no criticism, this appears to be something of a belt and braces measure. On my reading, at least, it doesn't cover anything which is not already covered in my ground one, so I don't intend to spend much of any time addressing that separately in my submissions. And maybe by the time we've heard Mr. Hutton, that position becomes clearer. As the court will say in respect of ground one, the claimant's position is basically a repeated invocation of the case of Cater. What I say to that is that Cater simply did not consider the question before the court today, and therefore cannot be a complete or indeed any answer to it. In respect of my ground two, as I understand the claimant's position is that there must be positive misconduct to engage the principle I rely upon. I say that's not correct by reference to principles and authority. Or, if that is a limitation, then the principle should be extended to overcome that for this class of case. My lady, my lords, I appreciate I'll deal very briskly with the facts because little, if anything, turns in them. And I appreciate the court's already got a grasp of them from what it has read.
Well, the detailed facts of the accident don't matter. It's just the chronology of the proceedings.
Absolutely, yes.
All we really need to know is that the offer was made and the period for acceptance expired before the case was allocated to the multi-track.
Just, my lord, yes, that's probably appropriate and fair. I take you to the offer and the acceptance themselves.
Fine.
So the offer is supplementary bundle, page 39. And I'm taking the court to that because, as we can see at paragraph 3, it's explicitly an offer to pay fixed costs. It does, of course, say within 21 days, but in my submission that cannot be sensibly be interpreted as an offer to pay higher costs if the offer is accepted late. It's point of return to, but the defendant made an offer for fixed costs. It wasn't open to the claimant to accept an offer for higher conventional costs. Although, and again, just in fairness, I should take the court to the acceptance. That's page 82 of the same bundle. So you can see that, in fact, the claimant said, we accept 45,000, your offer, 45,000, reasonable cost, we have standard basis, which is not the same as fixed costs. It might in fact be thought the parties weren't looking at those documents, the parties weren't at item, but neither party's taken that position from first instance onwards.
Yeah.
Defendant, all we did is to leave the offer on the table. The claimant could accept it on its own terms or not at all. And they certainly did. Claimant did not stand its ground and say, if you're insisting your offers for fixed costs, then we're not accepting it, we fight on. For reasons which are, the court has read the judgments below, I'm not going to go through them at this point, not least because it's a right or wrong answer point. It's not a question of interpreting nuance or factual findings or discretion. One of the learned judges has got it right and one of them's got it wrong, and this court will need to decide which. So I'll move directly on to my ground one, if I may.
Yep.
I'm following my skeleton just as structure, so this would be 15 if it assists there. So I'm first of all going to look at the relevant provisions, then very, very briskly indeed touch upon the relevant principles and then go on to my analysis. So I've set them out in my skeleton, but if the court prefers, they're found in the authorities bundles. The provisions that I'm addressing the court on, they are the ones which applied at the time in question. That's really just a numerical point. They're the same before and after for all material purposes. So the starting point would be Rule 36.13, and that's at page 16 of the authorities bundle. This is, we can say this is entitled Cost Consequences of Acceptance of a Part 36 Offer. 36.13.1, subject to paragraphs 2 and 4, which don't concern us, and Rule 36.20. I can just stop there, and we can see in parentheses beneath that, Rule 36.20 is flagged up again. It's a short point, but an important one. 36.13 is explicitly subject to 36.20. It follows that when 36.20 applies, 36.13 does not. If we move then please to 36.20, which is pages 32 and 33. Entitled Cost Consequences of Acceptance of a Part 36 Offer, where Section 3A of Part 45 applies. 36.21, this rule applies where a claim no longer continues under the RTA protocol. pursuant to Rule 4929A1. This claim before us is a claim which no longer continues under that protocol. It is therefore a claim to which Rule 3620 applies. And therefore it is a claim to which Rule 3613 does not apply. I underline that at this point because, as you've seen, the claimant argues that Rule 3613 governs this scenario. In my submission, that's simply wrong in plain reading. (3622) stipulates where a Part 36 offer is accepted within the relevant period, claimant is only entitled to fixed costs for the stage applicable at the date on which the notice of acceptance was served. Then the crucial one for our purposes is subsection 4. Subject to paragraphs 5, 6 and 7, where the defendant's Part 36 offer is accepted after the relevant period, which of course is this case, the claimant will be entitled to the fixed costs applicable on the date on which the relevant period expired. And then the claimant will in the normal way be liable for the defendant's costs thereafter. So in my submissions, my lady, my lord, the operation of the scheme is clear and logical. The costs on late acceptance are limited, as one would expect, to those costs which would have been payable had the offer been accepted in time. That works in a temporal fashion. That's how Part 36 works generally. That's also how the fixed cost regime works via temporal stages, and that's explicitly how this rule works, by reference to the stage and the date of the expiry of the relevant period. Could I then please skip ahead to relevant parts of Part 45, so page 154.
If we just look at sub-rule 12 for a moment,
Sub-rule 12 of
3620. Well, we'll start with 3624B. Claimant be liable for the defendant's costs for the period from date of expiry to the date of acceptance, but then 362012 says that the defendant's costs must not exceed the fixed costs.
yes.
So the defendant also, on
Absolutely.
your instruction, only gets fixed costs.
They do, although as the Cox rules were at the time, that's academic, because the defendant can't get any costs on late acceptance.
Yeah.
But yes, it's one of the general points I make. I say my interpretation reflects a proper balance between claimant and defendant, whereas my learned friend is a bit of a one-way bet.
Right, now you wanted us to go to?
I was taking the court to Rule 4529A, which is at page 154. So this is the start of section 3A, which deals with and governs ex-protocol claims such as this. Says this section applies to a claim which starts under one of the relevant protocols but no longer continues under it.
Yeah.
And then page 156, we have the section relied upon by the claimant, which is 45.92b, as amended to codify the ruling in Cater. So subject to various rules, including the exceptional circumstance one, for so long as the case not allocated to the multi-track. If claims started with the relevant fall, the only costs allowed are fixed costs.
Yeah.
So to make it clear to the court, obviously I cannot and do not dispute as a matter of generality if it's multi-tracks, not fixed costs, but it's whether that applies to the specific circumstances of late acceptance of Part 36. The general rule is not in dispute. That Cater only established a general rule. It did not look at the scenario in front of us. My lady, my lords, I've set out paragraphs 19 to 25 relevant interpretive principles. I'm not going to dwell on these at all because they'll be very familiar to the courts and they're common ground. But if I could just pick up on 2 points, please, within there. The first is the extract from Cook and Coss. That's to be found at page 452, 452 of the authorities bundle.
Four, 5, 2, did you say?
My lord, please, yes, 452.
Yeah.
And the court may have seen this from my skeleton argument. It's the letter striking, as it were, cartoon hero metaphor. There's a couple of points from here. First of all, it's not a criticism, it's the nature of these things. Claimants and their advisors will always try to escape fixed costs when they legitimately can because they're lower. It's just the nature of these things. It's equally the nature of these things that defendants will try and resist such attempts. The point is, the rules are drafted in, must be said, somewhat clunky fashion precisely to try and block off escape routes and to prevent escapology.
Yeah.
That's relevant here because the claimant's interpretation would license precisely the type of escapology that the rules are in fact designed to foreclose. The only other point I would go to here is briefly the case of Hassam, which starts at page 398, 398 of the authorities bundle. This was the Supreme Court's recent consideration of the proper interpretation of the whiplash tariff scheme, and the analysis obviously reflects the conventional purposive approach. If I could just skip directly to page 402, paragraph 47, speech of Lord Burrows, and one of the reasons he gave here for adopting the interpretation the court adopted.
Yeah.
I don't want to overplay it, but there are some parallels here. The idea of an interpretation which generates perverse incentives will normally be one to be rejected.
Yes.
So with the court's permission, I then move directly on to the analysis section of my argument under ground one, which would start at page, I beg your pardon, on page 26, paragraph 26 of my skeleton. And what my submission is that on proper interpretation, fixed costs apply by reference to any or all four following matters. First of all, purposive and contextual considerations.
Yeah.
Secondly, literal construction. Thirdly, that 3620 must prevail over 45.29b as far as there's irreducible tension or conflict. Fourthly, the terms of the offer itself, again, applying conventional principles. So my main point here under purpose of considerations, I've already flagged up.
Yeah.
Perverse reward for acceptance, it would be a windfall for the claimant.
Mm-hmm.
It would unjustly deprive the defendant of the proper or indeed any reward for making a well-judged offer. It being, of course, the claimant's interpretation, it would enable a claimant to escape fixed costs unilaterally and unmeritoriously. It would generate perverse incentives for late acceptance and potential manipulation of the rules.
That's the same as point one, isn't it?
Yes. Yes, they're not hermetically sealed. Well, I say they're not hermetically sealed. Your Lordship might say it's gratuitous repetition, but be that as it may. I do flag up that it would have the same impact if there were a failure to beat an offer at trial. So let's say rather than accept the offer, the claimant had went to trial and got judgment for 40,000. They still got the higher conventional costs for not accepting that offer than if they'd accepted in time. My submission, that's not how civil costs in general operate, nor Part 36 in particular. Civil costs in general, obviously, the starting point is costs follow the event. With a proper offer, that's the event. The reason you don't get your costs, if you fail to accept a reasonable offer, is you should have accepted it and stop the further costs continuing. It seems a fairly trite point, but respectfully, I do suggest the High Court judge rather lost sight of that. Part 36 reflects that rationale in an even stronger, more codified way. That was made clear in the OMV case, if I could take the court there.
Yeah.
Authorities Bundle, page 327, 327.
Do you need more than you've quoted?
Probably not, no. Could you just bear with me whilst I just check my notes in the judgment and make sure that I have nothing to add, please? No, I don't. The court, as I hope, got the point. It's carrot and stick.
Yeah.
And it's to encourage. Yes. Another trite but important point is how Part 36 operates to give effect to the carrot and stick, and it operates by placing the offeree on cost risk of contingencies which might occur in the litigation. So I take the court to the case of Matthews, page 252, 252 of the Authorities Bundle. So just to very briefly summarise the factual matrix: personal injury claim, the defendant made an offer, the claimant, not at all unreasonably, by reference to the evidence at the time, rejected as being too low. There was then a dramatic, unforeseen change in the evidence, which greatly reduced the claimant's life expectancy, which, leaving aside the human element, also inevitably reduced the value of the claim. So what was formerly a low offer became a very attractive one. The claimant accepted. The first instance judge held there should be no cost penalty for late acceptance, and this court reversed that decision. The manner in which it did so is instructive. I think I can skip to the main part of the judgment, which is paragraph 33 on page 259. Mr. Justice Stanley Burnton. Perhaps just invite the court to read that, or perhaps reread it rather than my reading it out.
Yep.
So my submission
I
here.
wonder how relevant all of this is to your argument, because the question for us is, as you graphically showed at the beginning, whether they get more costs or less costs. But the offer still gives you, your clients, cost protection in the sense that it puts the other side on cost risk, and it brings down the date, a shutter on the period in respect of which they can claim costs. The question is whether, when it comes to it, where there's acceptance, those costs are fixed or standard. But your client's still got cost protection from the offer.
It has.
It's just they get different cost protection. So I don't know that these general statements about cost protection and carrots and sticks really make very much difference to the question we have to resolve.
My Lord, I'm grateful. There's two responses to that. First of all, it does go to what's the likely legislative intention. Secondly, more directly, look at how Part 36 operates. As I said, it's to shift the risk of contingencies onto the offeree. Allocation or lack of allocation to a multi-track is a contingency. It's something which might or might not happen in the case as it progresses. The claims interpretation puts the cost risk of that contingency on me, the offeror, and should lie on the offeree.
Yeah, right.
Okay.
Of course, my Lord's right. If there's a case just giving us in clarity the right answer, then we wouldn't be here. But they do all. I'm inviting the court to look at the whole picture as far as it assists. So hopefully the court will see why I very respectfully say that Mr. Justice Stacey was quite wrong to say this is a windfall. It's the just reward for making a well-pitched offer.
Yeah.
I very respectfully say that's back to front. That's cannot be right. And of course, my Lord Justice Miles is correct that it's not that the offer gives us nothing, but it gives us a lot less and a lot more than it should under the way these things normally operate.
Well, I just wonder whether that depends on the outcome of this appeal. You get such cost protection as you get, as it were.
Yeah.
I just don't, at the moment, see that it really helps on the interpretation of these rules. But
Right, very well.
there it is.
There it is. Notwithstanding that, I will develop the points, and maybe they'll have more grip as I progress with them. The point I've already touched upon is that a defence Part 36 offer operates in a temporal manner, and that another authority which reinforces that point is the case of Gibbon, which I'll come back to in another context, but briefly now. It starts at page 269, 269.
This is Judge Brown's decision.
Gibbon. I'm sorry, my lord, you've lost me.
I think that's Ribbons, my lord, that your lordship is
Oh, right,
referring
which
to.
is-
This is Gibbon in this court.
Oh, right.
Yes.
Sorry, yes.
That's tab 13.
Yes. So, yes, page 269.
Yes.
And this decision, this court, the main point was whether contractual principles of withdrawal and counteroffers applied in Part 36. However, the passage I'd like to take this court to, if I may, is on page 278. This is the judgment of Lord Justice Mirbeck. It's at the bottom of that page, paragraph 32. The purpose of Part 36 is to promote settlement by encouraging sensible offers.
Yeah.
As Mr. Plume pointed out, every Part 36 carries with it certain consequences for cost linked to the date on which it is made, and the financial implications vary as the proceedings progress.
Yeah.
I mean, as it happens, it's not quite right, that is it? Because it's linked to the date of acceptance
Yeah, indeed.
or expiry of the relevant period.
I fully accept that. You may recall Honourable Judge Brown raised a question mark as to the relevant date is the date the offer is made or the expiry of the relevant period. My submission is quite clear, looking at the rules, it's the latter. So, but with that, my overall point remains the same. It works in a temporal fashion, and you wind back the cost clock and give the claimant the cost they would have got had they accepted the offer within that relevant period.
I noted with some interest Lord Justice Moorebeck's statement at paragraph 6. This is a procedural code which must be understood and followed by ordinary citizens who wish to conduct their own litigation.
It's perhaps might be politely described as aspirational. However, I'll come back that it is aspirational because it's more complicated than perhaps an ideal world it should be. It's that's just a matter of the drafting. It's perhaps reminiscent of the tourist in rural Ireland who asked for directions in Dublin and was told, well, to begin with, you're going to start from here. But yeah, there we have it. But there is a point there. Perhaps I'll just pick that up now, so me coming back to it later. It's not a perfect code that can be read very easily, but it should be no more difficult to read than is necessary. And there would be times when a litigant person would have to understand these rules. You could have an insured defendant EL claim, the insurer pulls the cover. You could have a litigant who has legal help to begin with, and then they go off record. So they do need to be, they're not just for lawyers. The point I'm making that context is this. A litigant person, and indeed a paralegal in a law firm or insurance claims handler dealing with bulk claims without the care that might be taken in a commercial firm looking at documents with a microscope, should be able to look at Rule 3620. So that says what it says, entitled fixed costs. Point as simple as that, 3620 should be interpreted to say what it says. That really goes to the key point of departure between myself and Mr. Hutton's submissions, because it's about the temporal aspect. Mr. Hutton says it's allocated to the multi-track, and that's the end of it. My response is, well, the point is if the claimant accepted the offer in time, it would never have been allocated to the multi-track.
No, we've got that point.
I'm obliged. My lady, my lords, I do rely quite heavily on the case of Ribbons, which is Honor Judge Brown's judgment. So I will go with that. No doubt the court will move me along if it thinks that I'm spending
It
too
doesn't
much time.
bind us.
It doesn't. No. Well, none of the three judgments before
No.
almost do. It's a question of, well, a question is which of the three has the most compelling reasoning. I would inevitably suggest Ribbons does, but
You've set out quite a chunk of it in your skeleton.
I have.
Do you need anything?
again, let me just
Its use is the extent to which it contains cogent arguments.
precisely so. Yes.
And you've set out on page, well, I've got it on page 26 of the bundle, paragraph 38,
I have. Yes.
the main parts of that judgment.
Indeed. Again, my lord, let me just go to my notes on my copy of the judgment and see what, if anything, I would add to that, if I may, rather than trawling through all the parts I rely upon. So the judgment starts at page 403.
Well, you tell us whether you need us to go there.
Very well.
Bearing in mind the amount you quoted.
My lords, no, I mean, there's points I could add, but they'd be pretty obvious. Honourable Judge Brown makes the point about the temporal operation. She makes the point about not incentivising, potentially incentivising bad litigation behaviour. And the point there is, make it quite clear, there's no suggestion that the claimant or solicitors in this case had any intention to manipulate anything. That's not the point. It's got to be directed against those minority who might so be tempted. So perhaps I'll just leave the court to consider that judgment. If the court finds it, the reasoning persuasive and compelling, that's just my argument. If it doesn't, then it doesn't. The next point I make here is that, and this may shed some light on the interpretive intention, is there are some passages in Sir Robert Jackson's final report which gave rise to these provisions, which I say assist. It's common ground that the identical predecessor within this rule was introduced simultaneously with Section 3A, the fixed cost section, as part of the Jackson reforms. So we looked a few sections.
Just say that again, I didn't quite.
Sorry, yes.
What was introduced simultaneously?
The predecessor to 3620, then 3610A, and Section 3A, which is the section containing 4529A and B. as the court will be aware, there was a raft of such reforms introduced to implement Sir Rupert Jackson's recommendations, or some of them, not all at the same time. Could I invite the court please to look at Authorities Bundle, page 453. You can see the highlighted sections under late settlements.
Yeah.
So one of the mischiefs identified by Sir Rupert was not just cases which didn't settle, but which settled later than they should have done.
Yep.
And one of the solutions was to give Part 36 more teeth, so juicier carrot and bigger stick, if I can extend that metaphor a little. And then the same point emerges on page 456, 456.
Yeah.
It may seem obvious, but my point is that the claimant's interpretation does drive a coach and horses through that rationale. Then perhaps even more clearly at page 474, 474. So this is looking at cost consequences in an ex-protocol case or a fixed cost case when a claimant fails to beat a Part 36 offer. The same rationale applies for late acceptance. And the intention of how that should work is clear and unsurprising. The claimant, when they don't take an offer they should have taken, they get their fixed costs or the costs which they would have received had the offer been accepted in time.
Again, I'm finding it a little bit difficult to see how that translates directly here. I mean, for example, multi-track proceedings are not being considered.
No, but the general point is that Sir Rupert Jackson identified late settlements, people not accepting offers when they should have done, as a mischief. He recommended numerous provisions, of which these are some, to address that mischief. It is unlikely to have been the legislative intention that the claimant gets a cost reward for late acceptance.
Yeah, I mean, here we've got a pretty prescriptive scheme in Part 36 and another scheme in Part 45.
Yes.
And I think we need to get to grips with what the rules actually say.
Yes. Indeed. My lord, taking that steer, I'll skip part. You also have made various other points about purpose of matters in my skeleton. I don't resile from those, but I'm not going to press them further.
No, we've read them.
Right, I'm grateful. One point I would just add to slightly is the relevance of the exceptional circumstances escape. Just briefly, Authorities Bundle, page 375. Hislop, it's paragraph 53. And albeit in different context, Lord Justice Coulson was identifying reasons why an interpretation of automatic disapplication of fixed costs was not to be favoured. One interpretive point telling against that was that a claimant will always have, in an appropriate case, the exceptional circumstances exit.
Yep.
And as the court's saying, the claimant here has always retained that option. That will, if this appeals allowed, that option will still remain open to the claimant. What the claimant's position, as I understand it, is that this became a multi-track case. It was always completely unsuitable for fixed costs, and fairness, amongst other things, demands conventional costs. If the claimant's right about that, that is precisely the type of situation which the exceptional circumstances provision caters for. And there will be no unfairness in the result. And that would apply to other claimants in similar positions. Conversely, if the claimant's wrong about that, then there's simply no unfairness in her being limited to fixed costs.
I'm afraid I don't follow this.
Yes.
If the claimant had accepted the offer within the time limited for acceptance, it would never have got anywhere near the multi-track,
No, indeed.
whatever the nature of the case.
That's indeed. I'm more making a point that's being made against me, which is the supposed unfairness. But the wider point is perhaps is this, it's the point of Hislop. Given that one has an escape clause for cases where fixed costs would be unfair, there's no reason to adopt an overly rigid interpretation. Oh my lord, I'll move on from that perhaps. Taking the court's cue, I'll move on to my second heading here, which is literal construction, which is back to the rules themselves. This is paragraphs 56 onwards of my skeleton, if that assists.
Yeah.
So I make several points here. My first point is one I've touched upon already by reference to the case of Gibbon, which is, indeed, I cite in my skeleton, paragraph 6, which my lord referred me to. 3620 is very plain and simple and says what it says. It's not subject to express being subject to 45.92b allocation of the multi-track or anything else. It is certainly a curiosity that these rules were introduced at the same time, yet certainly on the claims interpretation there's a problem between them. My lords, I don't know how much detail I would help to go into this, my lords, my lady. The legislative history, but perhaps, again, I'll start, and if it's unhelpful, I'll be moved on. So if we could please go to page 177 of the authorities bundle. These are when both the rules that we are looking at were introduced, 2013. Goes to page 128,
128.
120, I beg your pardon, 178.
Yes.
You see the introduction of,
What was there in Rule 3610A?
yes, precisely so.
Yes.
And then if one goes to page 181, 182.
Yeah.
And has the introduction of what, section 3A.
Yes.
Sorry, which one's that?
That's section 3A. So if one looks,
Go down at the bottom.
Yes.
Yeah, sorry, thank you.
so these are both introduced together. If there was some, and we know the intention was always that multi-track would exclude most fixed costs. It's unlikely the Rules Committee missed what would be a pretty glaring lacuna in 3620. Skipping ahead, please, to page 205. I beg your pardon, my fault, sorry, skipping back, if I may, to page 185. (214), there were further revisions of the rules.
Wait, which page are you on now?
185. 185.
Yes.
And 186, number 7, for part 36, substitute part 36 is set out in Schedule 1 to these rules. So a complete redraft, and that's when 3610A became 3620. Page 205, 205. The Rules Committee revisited.
This is following CADA.
Precisely so, that
Yep.
there's all the statutory instrument.
Yep.
It's codified CADA. We go then to page 208, 208. There was a further reconsideration of the rules to extend them to the package holiday claims. And then finally, page 212, 212. There was, as I've already alluded to, wholesale reconsideration of the rules to reflect the expanded intermediate track, etc. fixed cost regime. And just whilst we're there, on page 217, sorry, yeah, I beg your pardon, 216. (3623.3) as it now exists is in the dealing with late acceptance, essentially the same point, the claimant's limited to the fixed costs.
Yeah.
So the point there is that it's possible, highly unlikely, that the Rule Committee missed a pretty glaring problem with 3620, as is on the 5 different occasions they considered these rules. my next point here is that the claimant's interpretation of my submission gives Rule 45.29b a primacy which it simply does not in proper analysis have. Still in the authorities bundle. It's pages 154 to 156 is B itself. So if we search that, please. All 29B says is that for so long as a claim is not allocated to the multi-track fixed cost supply, in my submission it simply doesn't and cannot be properly read as overriding 3620.
Yeah.
Sorry, say that again.
In my submission it does not and cannot properly be read as overriding 3620. It simply isn't there and could easily have been spelled out if that had been the intention.
Yes.
Therefore, goes back to look at that in conjunction with 45.29a, which is on page 154. So, 1 says that this section applies to several classes of claims. So subsection 1, that defines the scope of section 3A. Rule 45.29b does not do so, because that's not what it says it does, and why would it need to, and that job is already being carried out by 45.29a. And there's no doubt this section 45.29a applies to this claim. It is a claim which started under the protocol. The point there is that the claimant's literal interpretation is that allocation of the multi-track displaces section 3a entirely. That's simply not what the rules say.
What would happen in a case where allocation to the multi-track had already happened before the offer was made?
Then the claimant will receive conventional costs.
Right.
Because it goes back to my point of the temporal fashion in which Part 36 operates.
But if that's right, isn't it because the case is no longer within section 3A? I just wonder how you get to that result as a matter of on your argument, which is that you only look at 29A.
Yes.
Your argument so far has been that, as I understand it, that 3620 refers to 4529A
Yes.
and not B.
Yes.
And you say, therefore, as long as it's an X protocol case, it's always within 3620. The question I have for you is, well, take a case where the claim has been allocated to the multi-track. It's still within the literal wording of 4529A, and yet you accept that that case would not be covered by the fixed cost provisions in 3620, as far as I can understand.
I do, yes. Because there not only have been allocation multi-track, there's no question of that there never should have been allocation to the multi-track. might be easier if we look just, it's certainly a case to which section 3A applies. They all are. The question is whether the fixed cost carve out at 29B applies, which is a slightly different question. It's possibly easier if we look at 3620 itself.
Page 32.
Page 32. It's rule 4, which is where the defence offer is accepted after the relevant period, claim be entitled to fixed costs applicable to the date when the relevant period expires. Now, if the relevant period expired after allocation of the multi-track, then there's no fixed costs applying, they're entitled to conventional costs.
And where do you get, where do you get the entitlement to standard costs? That's just saying, that argument is just one saying they're not entitled to fixed costs.
Yeah. Well, if you're not,
they're not actually limited to fixed
Yes.
costs, is what it really means.
if you're not limited to fixed costs, under Part 36 you get conventional costs.
So you go back to 3613.
Precisely,
As the default rule.
I fully accept that requires a somewhat purposive reading.
So then your reading of 3613 is that it is displaced for as long as there are fixed costs
Yes,
available.
indeed. Yes, indeed. They're mutually exclusive.
Yeah.
Yeah. It's one or the other.
And whether there are or aren't fixed costs available in the particular case depends on the date when the period for acceptance of the offer expires.
Precisely, yes.
Right. That's your argument.
That's
That's it, isn't it? Really?
Yes.
Yeah.
I apologise if I'm making it over elaborate, but that's they're not the easiest drafted of rules, perhaps. But
No.
I mean, paragraph 63, I've set that analysis out in a little more detail, but it doesn't. It's really drilling down into the point that my lord just used. I'd illustrate the point, or make the observation that the claimant's interpretation does, in my submission, entail rewriting 3620 to add in the words unless it's allocated to the multi-track, which 3620 simply does not include. Sticking with 3620 on page 32, it's entitled Cost Consequences of Acceptance of a Part 36 Offer where Section 3A of Part 45 applies. Yet on the claimant's argument, 3620 is ousted by 3A. That can't be right. You can have something simultaneously applying to incorporate something and ousting it.
You've made that point.
I'm obliged. So, if I'm moving on to my third point under this head, if I'm wrong about that, and there's a irreducible tension between 3620 and 4529B, my submission former prevails.
Yeah, and that's your reliance on Solomon.
It is, yes.
We've got that.
I'm grateful. Could I take the court to briefly to two more authorities on that point? Broadhurst, page 297. So this was another case concerning the interaction of these rules. And if I'll looks at page 301. We're looking at the same rules, and it's found to be an intention or a tension between the predecessor, that part of part 36, and 45.29b.
Yes.
And the short point was this court found that part 36 prevailed over 45.29b. Same approach was taken in Hislop. That was defending accepting a claimant's offer out of time, whether that space fixed costs. You can see just briefly page 370 to 371. Broadhurst was cited extensively.
Yep.
Then page 373, paragraphs 40 to 41. There's discussion of acceptance in Broadhurst. It was for the exception was the claimant bettering a Part 36 offer at trial. The question towards the bottom of paragraph 40, the point is made that the exception in Broadhurst was not made clear within section 3A, but it didn't need to be because it's already clear in Part 36. In my submission, the same logic applies here. So, and just the final point here, which is my fallback point, is paragraph 71 of my skeleton argument, is that insofar as an exception for late acceptance needs to be implied, it should be. The test is whether the implication is compellingly clear. The court can take a view as to whether or not that test is satisfied. My lady, my lords, I'm now moving on to the fourth strand of my argument here, which is the terms of the offer.
Does this really assist in the resolution of the question we've got to decide? Because both parties have accepted that it was effective, even though they seem to, on one view, on contractual terms, not have been ad idem.
Well,
I also notice, incidentally, that your offer actually refers to Rule 36.13
it does, yeah.
rather than 36.20.
Yes.
So, but as I understand it, everyone is saying you've got an offer which is to be treated as made under Part 36, an acceptance which is to be treated as made under Part 36. And so the question for the court is, what is the consequence of that under Part 36?
It is, but that doesn't mean the terms of the offer drop out entirely. The point I'd make is, it was 2 points really. First of all, we made an offer for 45,000 fixed costs. just as a matter of common
Well, if you
sense.
go down that route, then it's never been accepted.
Indeed, well,
Is your point more about not the terms of the offer, but the effectively costs environment, legal environment in which it was made?
well,
I mean, that there is a broader point
yeah,
there potentially.
yes, there is that, but when take a step back, all we did, having made the offer, was leave it on the table. It's for the claimant to accept it or not, or try and, so it's not quite fair to say you didn't put your foot down. We're just entitled to leave it there. The claimant could have said, no, we're not accepting in those terms, we will only accept in different terms. The claimant wanted 45,000, so they wanted the plum from the offer. They can't then exclude the duff of fixed costs. They're trying to accept something which,
I've got that point.
this might be a convenient point for me to look just briefly at Cater, which is of course what my learned friend relies on very heavily. Start at page 325. I beg your pardon, it doesn't. It starts at 308, thank you. I invite the court please to look at page 319. So Lord Justice Briggs, as he then was, paragraph 35B.
I must say, I couldn't detect in the judgments of Lord Justices Gross or Tomlinson any hesitation.
Any hesitation in the INCO point?
Well, Lord Justice Briggs says
yes.
after more hesitation than Lord Justices Tomlinson and Gross, and they just simply say that they agree. So where the hesitation comes from,
I think he
don't
was
know.
saying that he was hesitating more than them.
Yes, maybe.
So that when they said, I agree, without hesitation. I think.
Yes, right.
That's how I read it.
Yes. Or that they may be alluding to discussions they had before the judgment was promulgated. I don't helpful for
Anyway,
respect.
B, yes.
B, yes. I'm highlighting this said there. This in particular is not a case where the court has to resolve an apparent conflict between differing provisions in different parts of the CPR, considering the same subject matter. Nothing in the rules conflicts with the outcome I've just described. That's why Cater cannot be the final answer here, because there is a conflict between 36 and 45 resolved, and that simply was not for the court in Cater. Nothing suggests it was in the court's contemplation. And that same point emerges at paragraph 41 on page 321. I simply say this is a case like Broadhurst and Tan. My lady, my lords, I'll leave Cater there because it's more for my learned friend to do the running on that. Obviously, it is what it is as far as it goes. The question is, does it extend to the answer in this case? And my submission simply wasn't what they were addressing in this court. Unless I'm proposing to move on to my second ground now,
Yes.
unless there's any other point of ground one I insist. So this starts page 70, I beg your pardon, paragraph 76 is my skeleton. the starting point, if this ground succeeds, would have to be the same one I set out at the start. If the court accepts the proposition that it would be wrong for a claimant to receive significant extra cost for late acceptance as opposed to tenuous acceptance. If the court accepts that proposition but finds as a matter of construction that fixed costs do not apply automatically, my submission is they should be held to apply, in this and similar cases, indirectly. The High Court judge didn't accept the first proposition, so therefore, unsurprisingly, dismissed this in pretty short order. You've seen, the court has seen what I've said in my skeleton about the case of Williams, and obviously very much aware that one member of this court was in it, so I'm probably not going to have much.
Can't say I have any memory of it.
Okay, good. Well, good or bad, it makes it slightly less walking on eggshells trying to suggest the proper reading of it, but your lordship, better informed than I. What I say is perhaps the better starting point and more useful one is the case of O'Byrne, which Williams followed, so I could perhaps go to that first of all. That's tab 12, page 261. So, proceedings were issued claiming general damage more than 1,000 prior to allocation, settled for much less than the fast track small claims limit. The argument was whether or not the claimant should be limited to small claims costs rather than conventional costs. So a different type of fixed cost, but the same principles in my submission. And this court held that it's appropriate that small claims costs were the limit of what was reasonably recoverable. If we look page 265. The circuit judge citing from Lord Justice Judge in a case called Voice and Script International. So small claims costs, I'm not raising, don't apply indirectly, but it can still be restricted to that level.
Just before we go into all these cases, could you just give me a route map through the rules which get you to this?
Yeah.
This argument goes on the basis, does it, that 3620 doesn't apply for whatever reason?
Yes.
So we're back to the default position in 3613.
Yes.
Is that right?
Yes.
But you can escape from the default provision if making an order would be unjust. Is that the route through the rules to get to this?
The route is the claimant has an order for conventional costs to be assessed.
Right.
The route is those costs are what are reasonable and proportionate and are assessed at a level which is reasonable in all the circumstances.
Right.
And therefore they're assessed at a level equivalent to the fixed costs which would have applied.
So that goes to the assessment of standard costs.
Yes.
And how does that get before us?
In the same way as it did in Williams. Perhaps if saying that's troubling, Your Lordship, could I go back to Williams on that point? Well,
neither of the judges below, this is a discretionary decision, is it?
Yes, although one which must be trammeled by
Neither
principle.
of the judges below exercised that discretion.
Yes,
So you are asking us to exercise an original discretion, is that right?
correct, yes.
Which we can do if either of the judges, well, if the judge in the High Court was wrong. If she was right,
Yes.
what discretion do we have?
Well, if she was right, then you can't interfere with that. But the point there was that the High Court judge, she took the view that there was nothing wrong with the claimant obtaining higher costs for late acceptance. Now, if she's wrong about that,
So,
that's
so
her principle.
if she came to that conclusion, that was an exercise of discretion. Is that right?
Well, it would have been, but in my submission it would be on the basis of an error of principle. And that's the proposition that it's a party should receive more for late acceptance is wrong.
Right.
Now, as I said at the outset, if this court's against me on that, then
For your first premise, which she said,
Yeah.
you said she didn't
Yes.
accept.
Yes.
So you say that premise is wrong.
I do, yes. I'll come back to in a moment. This court in Williams was clear that in this type of scenario, the court sees with the point you grasp the nettle and determine it there and then, rather than kick it off to assessment, which defeats the purpose, in fact, which is to avoid the cost of assessment, or one of the purposes. If we could just continue through Byrne and then
Yes.
come back to Williams, please. Looking at the judgment of Lord Justice Waller, page 266, paragraph 16. Second half of that paragraph. But, and this is the critical point, in making an assessment, the cost judge is entitled to take account of all circumstances, CPR Rule 44.5.1 as the name was, including the fact the case would almost certainly have been allocated the small claims track if it had been allocated. Pausing there, what I say is that the pertinent circumstance here is that if the offer had been accepted in time, fixed cost is all that would have been recoverable. Paragraph 17. At that stage, the cost judge must question whether, if it could have been fought on the small track, it is reasonable that the paying party should pay the cost of a lawyer. I say the question here, is it reasonable that the defendant should pay conventional costs by dint of late acceptance? There's some further discussion about the test for proportionality in lines in the Home Office, which didn't detain us. If I could just skip ahead to the concurring judgment of Lord Justice Hooper, page 268, paragraph 22. Correct test, whether it is reasonable for the paying party to pay more than would have been recoverable in a case which should have been allocated to the small claims track. My submission, the question here is whether it's reasonable for the defendant to be paying more for a case which should never have been allocated to the multi-track. The other point, important point I would...
So can you say that again?
Yes.
Was it reasonable?
Is it reasonable for the defendant to pay more for a case that should never have been allocated to the multi-track because the offer should have been accepted? The question is, the overriding question is...
Yeah, the case was the nature of the case meant that it was allocated to the multi-track.
Mm.
So someone thought that was the right decision, and there was no challenge to that.
It's a,
So the case itself was appropriately turned out to be
Yeah.
appropriately a multi-track case.
yes, it turned out that way because the claimant didn't accept the offer in time. It's more basic.
Well, the case itself was a multi-track case.
The basic question I'm suggesting from this case is, what is reasonable in all the circumstances for the claimant to recover?
It's not really a question of whether it should have been allocated to the multi-track. Your point is a different one, which is that in some way, as I understand it, there's some injustice in the situation where the claimant accepts the offer after the end of the period.
Yes, I would do. I don't need to put that as high as injustice. The question is, what is a reasonable level of cost for the claimant to recover in these circumstances? On my submission, rightly or wrongly, the answer is what she would have recovered had she accepted the offer in time.
Can I just explore with you the difficulty I have with that it seems to me this is all rather circular, that if on the proper interpretation of the rules, the claimant is entitled to standard costs on the face of the rules in the circumstances which have happened, despite not accepting the offer within the relevant period. It's hard to see why there's anything unreasonable about the claimant then saying, right, I'd like my costs. But these cases are, as I understand it, cases where the court is saying, well, you should have done it under a process, or it's obvious that it would have been done under a process where you'd only ever have got fixed costs.
There's no finding in O'Byrne of that at all. There's nothing to say that.
Well, it says, is it reasonable for the paying party to pay more than would have been recovered in a case that should have been allocated to the small claims track? Is there anything on the hypothesis that you're wrong on point one? Is there anything unreasonable about a claimant saying, well, I just want what I'm entitled to under the rules?
It's not a question of it being possibly unreasonable. It is what is reasonable as between the parties.
Okay, well, can the claimant just say it's reasonable for me to?
It's reasonable for me to get more costs for accepting an offer.
It's reasonable for me to get the costs that I'm entitled to under the rules.
Well, my lord, no, that's respectfully that's not quite correct. What the rules entitle the claimant to are, on this premise, conventional costs to be assessed. That is not an entitlement for them to be assessed at a particular level, as not entitlement for them to be in Europe being assessed at a level to fixed costs. The claimant in O'Byrne and the claimant in Williams, they were both entitled to conventional costs. In neither case did that stop this court saying, yes, you are, but we're assessing a level equivalent to fixed or small claims costs. So there's not, my lord, there's nothing in my argument which in any way cuts across that entitlement. That's the point of these cases. The entitlement is to your reasonable costs, and reasonable costs can, in certain circumstances, be costs of level equivalent to fixed costs. Reasonable is, of course, a very open textured concept in these circumstances.
Your argument as to what should have happened in the O'Byrne should have been allocated to the small claims track. You're effectively saying you should have accepted the offer on time.
Yes,
That's
it, yes.
That's the, although it doesn't really deal with the multi-track point if the case was always suitable for the multi-track. It's
Well, yes,
happenstance when that allocation occurs, doesn't it?
Yes, but that's the case. There's plenty of claims which are always suitable for the multi-track, and if an offer is accepted in time. Again, the answer would be if it's clearly a case for which fixed costs are unsuitable, then that's what the exceptional circumstances provisions for.
Right?
So there's no, in O'Byrne, by the time the matter settled, it was clear that it would almost certainly have been allocated to the small claims track, but there's no finding of 4411 misconduct or anything like that. There's no finding, even as I read the judgment, that prospectively it was unreasonable to value the claim at over 1,000. It just settled beneath that. So there's no finding of unreasonable conduct in the positive
No.
sense at all. It's simply what's reasonable between the parties, and if it was always going to be allocated to the small claims track, it's not reasonable to. It's only reasonable for the cost to be assessed at that level.
Right?
Just very briefly with Williams. Go back to that. It starts at page 344. This was a case which should have been started under one of the protocols but was not. That being so, the rules precluded direct application of fixed costs. However, this court held that the claimant should not receive higher costs for not having followed the relevant protocol. Therefore, held that the claimant's costs should be assessed at a level equivalent to fixed costs. In other words, applied fixed costs indirectly. Again, taking this quite briskly because it's dealt with at some length in my skeleton. If one goes to page 350, I flag this up as a point against me just because I don't want to seem to be taking a bad point. I fully accept, as one sees at paragraph 27, there was a finding there that the claimant had not behaved reasonably. And what I simply say is, by reference to O'Byrne, that which was followed in this case, that is not prerequisite for this type of decision. Could invite the court then to look at page 351. And just invite the court to read paragraphs 30 and 31. This is the grasp the nettle point I was referring to earlier, that the court held here that the county court judge should have simply decided there and then that the assessed cost should be assessed at a level equivalent to fixed costs rather than generating the extra costs of a detailed assessment on what was a point of principle. If we could please then invite the court to look at page 355. Paragraph 57, support is drawn from O'Byrne. Paragraph 58, as it turns out, Mr. Hutton sought to distinguish this case on the basis that there was no unreasonable avoidance of the protocol. In my view, whilst that might be a difference in the facts, does not affect the applicability to Part 44. Any case where the pay might otherwise recover more than is reasonable in all circumstances. And that's my submission, that's the key concept. When you have an order for conventional costs to be assessed on the standard basis, you're entitled to cover what is reasonable in all the circumstances, and that in the appropriate circumstances can be fixed costs or the equivalent without any need for 4411 misconduct or the like. Paragraph 59.
Is that right? Because at 55, last sentence, Lord Justice Coulson says the unreasonable failure by the claimant to follow the protocol triggers the conduct provisions.
Yes, that was true in that case, but that it's not so limited in my submission as O'Byrne demonstrates. Or if I'm wrong about that, it should not be so limited.
Right.
The paragraph 59, there's a description of how the practicality of this might work. It's the final sentence on page 356. If the judge concludes as a result of unreasonable conduct, the relevant fixed costs represent the maximum recovery, then item by item approach is unnecessary. On paragraph 62, reiterates the point that it's preferable to grasp the nettle, as I put it. So my lords, obviously there's some emphasis placed on the court in Williams as unreasonable conduct, but as I've said, by reference to O'Byrne, that's not prerequisite. It would obviously strengthen one's hand if we're there. The basic point is inter partes reasonableness, and that's the point at which I pray and aid. Could the court just excuse my back a moment whilst I check if there's anything on this? Is there any, those are my submissions, unless there's any other point upon which I can assist the court at the moment. Thank you.
Yes, thank you very much, Mr. Roy. We'll just rise for a couple of minutes to see where we get to. Please don't leave the courtroom. We'll be back very shortly.
All eyes available? ayes are favourable.
Yes, Mr. Hutton.
Yes. Lordship's in relationship. My submission is, I hope, relatively simple. It is actually quite a narrow point, although of course there's a lot of stuff around it. But there's a narrow point here as to we say that this court in CADA decided, found, and in Mrs. Justice Stacey's words, has done the heavy lifting for you, that those legislating for the fixed cost regime in section 3A of part 45, those legislating did not have the intention that that fixed cost regime would ever apply to a case allocated to the multi-track. And that was the clear finding, having gone through all the relevant matters to the lawmaker's intention. And in the light of that, we say that the High Court Judge, Mrs. Justice Stacey, was right for the reasons that she gave, namely bearing in mind that intention that fixed costs should never apply to a case which is allocated to the multi-track. If you apply a literal or purposive interpretation of the rules, the allocation of this case to the multi-track meant that fixed costs were automatically and completely disapplied. And the consequence of that in the context of Part 36 was that when the Part 36 offer was accepted by the claimant, albeit outside the 21-day relevant period, 36(13)(3), which obviously I'll come to, provides, except where the recoverable costs are fixed by these rules, costs under paragraphs 1 and 2 are to be assessed on the standard basis if the amount of cost is not agreed.
So
Now,
literal was that?
that's 36(13) subparagraph 3. So except where the recoverable costs are fixed by these rules, or we say the recoverable costs are not fixed by these rules because of the effect of CPR 45.29b and the legislative intention as explained by this court in CADA, which is if it's a multi-track case which has actually been allocated to the multi-track, fixed cost regime cannot apply to it. It is automatically and completely disapplied from such a case. So if the recoverable costs are not fixed by the rules, and we say they're not in light of the change to the rules in 45.29b to reflect the legislative intention, if they're not fixed, then CPR 36(13) applies.
Well, aren't there two possible sources within the rules of fixing the costs? One is 45.29b,
Yes.
and the other is 36.20 itself.
Yes. Well, what we say about 3620 is that it is simply seeking to apply section 3A in the context of part 36.
But if that's all it was doing, why would sub-rule 4 have been necessary?
I'll just remind myself of sub-rule 4. So subject to paragraphs 5, 6, 7, where a defendant's part 36 offer is accepted after the relevant period, the claimant will be entitled to fixed costs to the date relevant period expired, and then the claimant will be liable for the defendant's costs for the period from the date of the expiry. Well, my lord, that is seeking, as I understand it, to implement section 3A so that the claimant will be entitled only to fixed costs up until that date. So, and that's what section 3A says, you can get fixed costs, and all 3620 is saying is you get your fixed costs up to 21 days after the offer was made. So it's implementing section 3A.
So the fixed cost regime is not retrospectively disapplied on this reading. Your client would be entitled to have fixed costs up to the date of when the offer expired and standard thereafter?
If we come within 3620, but we have two answers to that. One is we don't come there at all because we are not fixed, and therefore 3613(3) applies, namely standard basis costs. If you're not fixed, you're standard.
Right.
We're not fixed because of the effect of section 3A. So therefore we don't come in within 3620 at all. Alternatively, if we do come within 3620, 3620 has got to be read in the light of what section 3A actually says. And section 3A says that if you're allocated to the multi-track, the fixed costs in section 3A do not apply to you. Now, there might be, I accept, an argument which I would say would be angels dancing on the head of a pin as to whether section 3A itself is disapplied to a case which is allocated to the multi-track, or the fixed cost regime within section 3A is disapplied. But since section 3A is the fixed cost regime, that's what it does, those ultimately don't make any difference. We say we are in effect either outside section 3A altogether, or if we're inside, we're an exception, an express exception that says that the fixed cost regime does not apply to us. And if you do have to go to CPR 3620, and I accept, and Mrs. Justice Stacey accepted, that the wording of the rules, and Malone Friends accepted, the wording of the rules is not entirely happy or entirely easy, but I accept that in that light, and Mrs. Justice Stacey accepted that ideally 3620 probably should have been updated post-CADA to reflect CADA, and it wasn't. But we say it has to be read in the light of CADA and the change to the rules that reflected the legislative intention of section 3A. Well, can I come to that in a minute, in a few minutes, in more detail? But that's essentially what we're saying. Now, there's been a lot of reliance on the other side in terms of the merits of the position, and of course, this court will bear in mind the merits of the position. That's part of the purposive interpretation. Malone Friend puts it as simply as, well, we're getting more because we accepted late. And that's a fair point to make, that is true. If we're right and the judgment upheld is upheld, then we do get more as a result of accepting late. But the merits aren't all on one side. And as was pointed out earlier by Lord Justice Miles, this was a case which the court found was suitable for multi-track. It was a multi-track case, and CADA tells us that the legislature did not intend that multi-track claims should have the fixed cost regime. And not only that, if one looks at the chronology, at the time the offer was made of 45,000, which is more than the fast track limit at that time, 25,000. It's not strictly a limit. it's the court has a discretion as to which to allocate to, but the normal track for a claim of £25,000 or less will be the fast track, and the normal track, this is obviously all before the intermediate track, which now applies, but the normal claim for 45,000 would be on the multi-track. Not only that, but as we'll see in this case, there was permission for the claimant to rely on 6 different experts and the defendant to rely on 4 different experts in this case. Whereas normally under multi-track, you won't have more than 2 experts. So this was clearly a multi-track case. The defendant made their offer when they were aware, or they should have been aware, and this was in fact found by His Honour Judge Duddridge at first instance, they were aware that this case was likely to be allocated to the multi-track when they made their offer. Now I accept that the way that the rules work is if we'd accepted the offer within the 21 days and therefore before allocation to the multi-track, we would have been fixed with fixed costs. I accept that that's how it works. And we can see from CADA that this court considered that issue and said we would prefer just to have a bright line. Once it's been allocated to the multi-track, fixed recoverable costs go completely. But until it's allocated to the multi-track, fixed recoverable costs apply. So that's the bright line. So I accept that if we'd accepted it within the 21 days, we would be caught by fixed recoverable costs. But the defendant made an offer when they knew that this case was very likely to be allocated to the multi-track in order to get an advantage, not an illegitimate advantage, that's how the rules work. But it is an advantage, and all that's happened, we would say, is that as a result of Mrs. Justice Stacey's decision, the claimant is getting the costs that are suitable for her type of case, namely a multi-track case, and only up to 21 days after the offer was made. And there's no injustice in that to the defendant. So justice isn't all one way in this case, and of course those were features of Mrs. Justice Stacey's judgment. So, my lord, in terms of the facts, and I'll deal with this very briefly because I've heard obviously what the court has said about this. It's important to recognise that the original claim under the RTA protocol was made 10 days after the accident. So very soon afterwards, when the claimant didn't actually know how things were going to turn out. It then exited the protocol because the defendant denied liability and then later admitted liability. There is, by the way, just in case it features in the judgment, there is an error in my skeleton, in our skeleton at paragraph 6.3. The defendant, the claim exited the protocol on the 9th of April 2018. The admission of liability was the 29th of April 2019, not 2018 as was stated, so just over a year later. And I won't go to the references in the supplementary bundle unless the court wants me to. But it is, I would submit, important to recognise in the supplementary bundle, and I will go to this point if I may, at tab 5 in the supplementary bundle on page 32 is the claim form. So this is now issued in February 2021 and the accident was March 2018. At that point in the particulars of claim, the claim form, on page 32, the claimant expects to recover up to £150,000 on the value on page 32. And then if one sees on page 36, the particulars of injury, the claimant was already relying on 3 medical experts at that stage. Whereas normally on the fast track you would be limited to 2.
Yeah.
And again, you needn't turn it up, but paragraph 2 of His Honour Judge Duddridge's judgment references Crawl 12.159. We can go to this briefly. It's 159.
Yes.
Paragraph 2, the last sentence, it was probably clear from the outset of the claim that this was likely to be allocated to the multi-track in due course because of the high value that was placed on it, as well as the number of experts that the parties were likely to require. And indeed, the court sent out a proposed allocation to the multi-track with a question as to whether either party wanted to take issue with it, and that's tab 12, page 53 of the supplementary bundle, and the defendant did not object. So they accepted that this was a multi-track case, and eventually then in January 2022 it was allocated to the multi-track, and again it was tab 16 in the supplementary bundle is the directions order of the Deputy District Judge, and on page 60 is a list of all the experts for whom permission was given. And as I said, there were 6 experts on the claimant side with permission and 4 from the defendant. And the trial was listed for 5 days.
Yeah.
So it was clearly a multi-track case, and I don't think anyone is disputing that. Can I then, and going back to my Lady Justice Falk's point about happenstance as to when the allocation takes place, I think it was perhaps particularly slow in the county court at this time. I think it was probably COVID. In 2021, it took a year for them to get a directions hearing on. So, but whenever that was to happen, the court had already indicated that it was likely to be allocated to the multi-track, and no one had taken issue with it. Can I then come to the rules, which I know is at the centre of this court's concern, and start with CPR, section 3 of part 45A, which starts at tab 3 in the authorities bundle at page 151. Sorry, 154. So section 3A, obviously there's a fixed cost regime if the claim stays within the protocol, and then a fixed cost regime if the claim starts in the protocol but leaves it. And section 3A is claims which no longer continue under the RTA protocol. And 4529A says that this section applies to a claim started under the RTA protocol where such a claim no longer continues under the relevant protocol. And we accept, of course, that on the face of 4529A, it covers us, because this was a claim that started in the RTA protocol but no longer proceeded. But then one has to go and look at 4529B, which is on the next page, 156, which says, headed application of fixed costs and disbursements RTA protocol, subject to rules, those rules, which we can come to if necessary, and for as long as the case is not allocated to the multi-track, if in a claim started under the RTA protocol, the claimant notification form was submitted, which it was, then the only costs are the fixed costs under 4529C and disbursements under 4529L. So the words "for as long as the case is not allocated to the multi-track," as the court is well aware, were inserted following this court's decision in CADA. Just on that page in the White Book notes, cases allocated to the multi-track there, section highlighted, section 3A of part 45 does not apply to claims allocated to the multi-track, even if they were started under the protocols. And that's what it says CADA is. Now that raises the issue of whether section 3A applies or the fixed cost regime which is provided by section 3A applies. And strictly it is probably the latter, but section 3A is the fixed cost regime. That's what it is. So if the fixed cost regime in section 3A doesn't apply to you, then in effect, section 3A doesn't apply. If the court follows that section.
Yeah, I mean, that depends, doesn't it, on how you interpret 3620.
Yes, yes, I accept that. I accept that. I mean, the editors of the White Book say section 3A doesn't apply to a multi-track case. That, you know,
They may or may not be right.
well, they may or may not be right. In my submission, that what the Court of Appeal in CADA was saying, and we'll come to it, was that these words they added, "and for as long as the case is not allocated to the multi-track," were intended to reflect the intention of the rule makers that if you're allocated to the multi-track, you come out completely of the section 3A fixed cost regime. You simply leap away and you're no longer covered. And I accept there is that kind of what I term angels on the dancing on the head of the pin issue about whether actually you're outside 3A, because actually strictly you're within section 3A, but you're an exception within section 3A to the fixed cost regime.
And you say that it's purely the wording that was inserted after CADA that does that?
Yes, yes, absolutely, my lady. The wording which reflected the legislative intention which had failed to make it into the rules previously.
The wording is "for as long as the case
Yes,
is not allocated."
yes,
So that envisages that these rules do apply. And it seems, on the face of it, it's wording about to do with timing.
yes,
But there is a point when it's allocated to the multi-track, and that's the point when things change.
yes,
In other words, the rule no longer applies.
yes,
But it does apply on the face of it for as long as that is not the case.
yes. So I accept that, with the greatest respect to the court in CADA, that wording is slightly ambiguous on its face, because it might be read as that the fixed cost regime applies to all the costs that you incur up to the date of allocation to the multi-track, and then standard basis costs apply thereafter, which would be a very odd exercise, but you'd have to work out what the fixed cost regime were up to that point, and then standard basis thereafter. But my submission is that if the court reads CADA, it is absolutely clear that what the court was intending by inserting those words was to reflect the legislative intention that it is completely disapplied. The fixed cost regime on section 3A is completely disapplied in a case that's allocated to the multi-track.
So do you read it, or do you think and should read it as unless the case is allocated
Yes,
to the multi-track?
yes, yes, my lady. But I suppose what might be intended by those words is that until that moment of allocation, it is covered by the fixed costs.
I think that's possibly what the report was getting at, given the debate that you touched on earlier about where to
Yes.
draw the line.
Yes, exactly. Yes.
But it is puzzling wording.
Yes. No, I accept that, and it may then be helpful. I'm not sure I need to go through the rest of 45 of section 3A.
There is
Yes.
this was, I think, referred to in a case in this court, wasn't it? Which I noticed on reading, where page 394 of the Ballantyre.
Yes.
Which this is Lord Justice Newey in a case
Yes.
referring to these words for so long as the case is not allocated to the multi-track. He's dealing with the submission that regime would automatically cease to apply from the start on reallocation. And he says this is very far from obvious.
Yes.
More natural interpretation might be thought to be that where a case is transferred from the multi-track, fast track to the multi-track, the fixed cost regime ceases to apply prospectively, not in relation to past costs incurred on the cases in the fast track.
Yes.
So Lord Justice Newey thought that that was a more natural interpretation.
Yes, I accept that. But my submission is that if one reads CADA, it was quite clear that this court was saying that what those words mean is that the fixed cost regime do not apply at all if the case is allocated to the multi-track.
Now that's difficult for you, isn't it? Because Lord Justice Newey is explaining what CADA decides in that very paragraph.
Well, it's that I think is obiter. I don't think that's the ratio of the case. And if one goes to CADA in my submission, I don't know. Well, so if one goes to CADA, in my submission, it is clear from what the court is saying that.
Sorry, let me just get CADA. Yeah.
Yes. So
Tab
CADA
17.
is at tab
Yeah.
17,
Yeah.
page 308. Can I just pick up a few points before I come back to that issue, because it might make more sense just to go through the judgment. On page 311, this is obviously the judgment of Lord Justice Briggs, as he then was. There's a section starting the RTA protocol, and the RTA protocol paragraph 2 provides an efficient modern framework for the resolution of modest personal injury claims arising out of RTAs. And then at paragraph 3, it says the RTA protocol was not designed for the resolution of large claims or complex disputes. And at paragraph 5, a detailed and comprehensive fixed cost regime has been an essential foundation for the effectiveness of the RTA protocol. So that's the fixed cost regime. Paragraph 6 deals with where cases may leave the protocol for various reasons. Paragraph 7, those proceedings will, if liability remains in dispute, typically lead to allocation to the fast track and a trial taking not more than 1 day. So that's what's envisaged. And then at paragraph 9, fixed cost regime. And then at paragraph 15, if I can go to that, sets out the regime. And at 15, says this: as is apparent from Rule 26.6, the fast track is the normal track for proceedings in personal injury context, where the claim lies between £1,000 and, after April 2009, £25,000, but only where the trial is likely to last no longer than 1 day, and expert evidence is limited to 1 expert per party. And then missing out a sentence, but claims for an amount of more than £25,000 or claims likely to require a trial lasting more than 1 day, or the deployment of multiple expert witnesses, are normally allocated to the multi-track. Plainly, they involve expenditure of costs on a scale which will always be higher, and often much higher, than that requisite for the determination of claims in the fast track. Just as personal injury claims for less than £1,000 are inappropriate for the protocols, so are claims for more than £25,000, so that there is an initial apparent symmetry between the scope of the protocols and the fast track in terms of the amount claimed. So pausing there, in our submission, we are a case that shouldn't be within the protocol. And once it leaves the protocol because liability is denied, it does not fit into the usual category of cases which take a day with no more than 2 experts. It's got multiple experts, it's claimed at much more than £25,000. And then at paragraph 16, there are a number of situations where claims properly started in the RTA protocol which no longer continue therein due to a dispute as to liability, but are pursued under Part 7, are likely to have been allocated to the multi-track rather than the fast track. 3 examples were identified during the hearing of this appeals. The first arises where the claim originally thought to be worth no more than £25,000 is revalued at a substantially higher level. These then cease to continue in the RTA protocol. It may not automatically follow that such a claim would be allocated to the multi-track, because the £25,000 limit for the fast track is one which only makes it not the normal track, and the court retains discretion on grounds of in Rule 26.7 to allocate other than the normal track. Nonetheless, a large escalation in the amount claimed is inherently likely to lead to intensification of the litigation about its quantification, sufficient to take the case beyond the 1-day trial estimate, which is a key feature for allocation to the multi-track. And again, we pray that in aid that this is one of those unusual cases, but cases which do occur, where it's clearly not appropriate for the fast track. Then at paragraph 19, on the second sentence, the result is that, subject only to the prospect of obtaining a greater amount than the fixed cost pursuant to an application under 4529J, that's the exceptional circumstances jurisdiction, the claimants in each case and their solicitors face the unattractive prospect of pursuing claims and resisting serious allegations of dishonesty. In those cases were allegations where the accidents were staged in order to get money. Both cases in CADA were that. So the unattractive prospects of pursuing their claims and resisting serious allegations of dishonesty at trials likely to last well over 1 day, but upon the basis of a fixed cost regime, which, as will appear, was plainly designed to be suitable only for fast-track cases. That was indeed the conclusion reached by the judges. But we say, similarly, the fixed cost regime is unattractive for clients, but also for solicitors, in cases like this, which are worth much more than £25,000 and have many more experts than are envisaged in the normal fast-track case.
But it's a very different situation to say in CADA. The contrary result would have been, as indicated here, that the entirety of a complex trial would be conducted under a fixed cost regime, and that and other considerations led their lordships to decide that this was an Inco Europe case,
Yes.
where there had been an error. We're primarily, suggest, interpreting Part 36 here, and doesn't seem, to me at least, speaking for myself, that the error jumps out of being of that nature. Not at least not obviously to the same extent.
Well, I mean, I think I would have 2 points in response to that. Firstly, in relation to the present case, the incurrence of costs, even at a relatively early stage, because this case didn't make it to trial, is inevitably going to be much higher in a complex personal injury claim where much more than £25,000 is claimed, and where the claimant has 6 experts. Now, I accept that in the fixed cost regime, you get your disbursements. So the expert fees, you might say, well, they're covered anyway. But the solicitors and counsel obviously have to do a lot more work dealing with 6 experts than they would dealing with 1 or 2 on the fast track case.
Lord Justice Briggs, I don't think, said a word about Part 36 in this judgment.
No, it didn't arise.
He is contemplating a case which goes to trial, essentially. Had your client accepted the offer within the period for acceptance, the question of multi-track would never have arisen.
No, I accept that. Although it was obvious that it was going to be allocated, it hadn't been allocated.
It was obvious that it was going, I mean, the highest you can put it is it was obvious it would be allocated to the multi-track in the event that the offer was not accepted.
Yes. Yes, I accept
But but that is the very event on which we are focusing.
Yes. Yes, but the CADA case is that the point at which that arose was as to whether cost management should apply or not, because if it was on the multi-track, it would need to be cost managed.
Certainly.
And so that's how the appeals came to this court. So it wasn't after a trial, although obviously by doing cost management, you're envisaging that it might go to trial. I accept that. But I think, I mean, I would submit that the same point applies in the sense that there is an awful lot more work to deal with a complex case with multiple experts at an early stage, just as much as there is at trial.
Yeah.
I understand that point, but you still then have to deal with the fact that if it had been accepted at the end of the 21-day, by the end of the 21-day period, then fixed costs apply. In a sense, you're not, let's say, trying to apply CADA in a way that avoids that consequence.
No, I'm not. No, because it doesn't, and that's clear from paragraph 55 in CADA, which says clear bright line. It's allocation itself.
And there's a real difference, isn't there? Your client always has an option to refuse to accept an offer made before allocation.
Yes.
The multi-track. It's not the same as CADA, where the parties get stuck if a trial happens. The period reached the opposite decision. Both parties are stuck with a fixed cost regime.
Yes. Yes, I mean,
there's an optionality on Part 36. That's the whole point.
Yes, I mean, if one looks at the rules in relation to in relation to a case that goes to judgment, this is not our case. We're 3620, but 3617 and 3621 deal with if you go to court, if you go to trial, and you recover less than the defendant's offer. As one of the points. I'm conscious of that clock. That clock.
That clock is fast.
Is fast.
Yes. It's about 5 minutes fast, I think.
Yes.
4 minutes fast. So carry on if you want.
I'm grateful. And similar wording is used in 3621 as 3620. So the point would apply if the case had gone to trial. I mean, it might be that. Part 36 offer was made 22 days before trial, and therefore the vast majority of the costs were incurred by the time that the offer was made, and yet the claimant decided not to accept that offer and went to trial. On my learned friend's argument, as I understand it, they would be fixed with fixed costs in those circumstances because
Well, I
30.
think he said
No,
that
yes.
if the case had already been allocated to the multi-track,
Yes.
then they wouldn't.
Yes, and that is a point that I don't think was argued in front of Mrs. Justice Stacey. I'm not complaining. It's just that's why that point doesn't feature in her judgment, because what my learned friend has called the literal interpretation here relies heavily, and I think he said it during his submissions. 3620 simply speaks for itself. It covers any case which started in the protocol and left it, and therefore you get fixed recoverable costs, notwithstanding CADA. Now, we say that must be wrong because it can't be the intention of the rules that CADA has no effect simply because there's been a Part 36 offer. CADA must have an effect in relation to, so in relation to 3620, it can't be simply that if you come within 3620 because you've left the protocol, therefore you're fixed with fixed
I
costs.
think he's accepted that.
Yes. Yes.
Can are you just on CADA?
Yes.
And the bit which leads to these words and so far as long as the claim is not allocated to multi-track is towards the end.
Yes.
And Lord Justice Briggs says in 54 that the change that needs to be made at the end of that, around D, similarly the substance of provision that the Rule Committee would have made if it had taken steps to enact the restriction would have been to provide that from the moment when a case was in fact allocated, the Section 3A fixed cost regime should cease to apply.
Yes.
Again, there seems to be some sort of temporal thing there.
Yes. But again, we would,
I can see it's ambiguous.
it's consistent with the idea that until that moment you get fixed costs. So if a case settles or whatever, you get fixed costs. It's the allocation which then suddenly changes everything. But then if one goes on to 55,
He says people shouldn't have to guess in advance
exactly.
of allocation. But again, that seems to be saying that the fixed cost regime does apply until allocation has actually occurred.
Yes, but then if one goes back to 35D on page 319320, careful analysis of the historical origins of the scheme now enshrined in section 3A, part 45, demonstrate that it was not in fact the intention of those legislating for this regime in 2013 that it should ever apply to a case allocated to the multi-track.
Well, it suffers from a similar ambiguity.
He seems to be making a general point there that
Yes.
what he seems to be saying is that it was never the intention of the legislature to apply this regime to multi-track cases.
Yes.
And that's the general point. But it's really at 54 to 56 that the suggested change is made.
Yes.
And that's ambiguous.
Well, then if one goes forward to, I'm conscious of the, obviously the time, but it goes forward to the end of 59, I would therefore allow the appeal, dismiss the appeal. If allocation of a case to the multi-track automatically disapplies section 3A fixed cost regime,
Sorry, where are you?
sorry, 59
59.
on page 326, third sentence of 59. The allocation of a case to the multi-track automatically disapplies the section 3A fixed cost regime. There is no need to consider at that stage relief under 4529J. Now, that is consistent, isn't it, in the fixed cost regime not applying at all, because relief under 4529J, if the fixed cost regime applied up to the date of the allocation, then relief under 4529J might be relevant to the costs up to that date. We would say that that is consistent with a complete disapplication. Because once you decide a case is a multi-track case, then you should get multi-track costs.
Yeah.
And that's throughout, not just prospectively. My lord, that is past 1 o'clock.
Right, thank you very much. 2 o'clock.
All rise if able.